People who work in the juvenile justice system, they know this. They know that the longer you can keep a young person from having contact with the criminal justice system, especially court, the less chance they have of becoming a career criminal later in life. You don't want some kid to be stuck in a juvenile justice centre, so a kid jail, with a whole bunch of the hardened repeat offenders and crazies. You don't want them stuck there for making a dumb mistake. Plus, you don't want the young person to be labelled, and kids label themselves as well as other people labeling them. Kids label themselves as a criminal from a young age. So when they end up in court, they go, okay, this is kind of who I am, because they're still looking for their identity. So the New South Wales government actually passed a good law, and it was way back in 1997. But credit where credit's due. The New South Wales government hasn't passed a lot of good ones since, but they passed the Young Offenders Act, which allows police to divert, so to move kids away, to move kids around having to go to court at all. Now, the three main ways of diverting the kids away from going to court, so non-court ways, are warnings, cautions, and youth justice conferences. Because police are able to actually, send a kid to a youth justice conference. They can set it up, directly, rather than sending the kid to court, and court really is the toxic thing. So if you look at our original diagram, we did the red ones, and we looked at control orders and fines. Now we're really going to look at the green side. And this is green because these are alternatives to having to go to court. These are the less toxic versions. And about half of the young offenders that have contact with the police get diverted from formal prosecution, from having to go to court, which is a good thing, but still it means that half don't. That half of the kids do end up, going to the children's court. Now, warnings are issued by the police for minor offences, and so it can't be a violent offence or anything like that. Now, the kid doesn't have to admit that they're guilty. So if you're a teenage kid, you've done the wrong thing, you can get a warning, but you can keep saying, no, I didn't do it, and it doesn't stop them from giving you the warning. So what the police do, they write your name down and the date and the place and all that sort of stuff, and there's no penalty, there's no fine, there's no criminal record, but it can be used against you later. So if the police bust you, 2 days later doing the exact same thing, you go, oh no, I didn't know, and they can look it up and they can go, well, you were warned about this 2 days ago by this officer and this So young people can have that kind of held against them, but it's not a formal criminal record. Now, young people can be warned more than once, and really as many times as the police are willing to let them go. A caution is a little bit different. It's for more serious offences, obviously not like murder and stuff like that. But the difference is the young person has to admit guilt and consent and say yes to getting the caution. The warning, like the police just say, look, you're getting a warning, even if the kid doesn't want to or anything like that. But to get a caution, the kid's got to admit guilt. The reason that a kid would admit guilt in this sort of situation is they don't want to go to court. Yeah. They're still issued by police, still no criminal record, still gets recorded. But in terms of the number of times you can be cautioned, no more than 3. After that, there's really no discretion for the police anymore. You're going to go to court. Now, the young person can have to write an apology, but there's no fines or anything else. So really, a formal caution, is about as tough as you can get without having to go through any formal processes like a court system. And youth justice conferences are our third option for diverting kids away. Now, the young person has to, admit guilt. They have to accept responsibility for the offence. There's no point in putting a kid there who's going to keep denying it and have them in front of the victim and make the victim more upset. And it allows the victim to say how they've been affected by the crime by sitting them down and talking to the young person, straight to them, not just writing a letter or something like that. This process is more about rehabilitation or restorative justice, and we looked at restorative justice earlier. Not just punishing the young offender. So control orders, often about punishment, even though rehabilitation should be like the main goal. But youth justice conferencing is all about restorative justice. What happens at the end of it, after they have all these discussions, is that they get an outcome plan. The offender signs it and they say, yes, I agree on this date that I'm going to pay back the victim. Sometimes it means like working for them or, painting the thing that they smashed or whatever. Apologizing, going to counseling, all these sorts of things. And if they don't do it, they're going to end up in court instead, which is really, not what they want to do. In terms of the youth justice conferencing The problem with it, and we sort of looked at this a little bit in diversionary programs for penalties, is that if you look at the green and the red side, you've got youth justice conferencing going down the middle. There's two ways you can get there. You can get sent there by police, or you can get sent there by a court. But remember, the court is the toxic part. 40% of kids who end up in a youth justice conferencing situation were sent there by police, but 60% were sent there by the court, by a magistrate. So really, the question that was raised in the Noetic review, and I fully agree, is what's the point of having something that diverts you away from court if you have to go to court to get there? If most kids who are ending up in youth justice conferencing to avoid going to court have to go to court in the first place to get sent to avoid court, it's really not going to be working. So that's probably hurt the effectiveness of youth justice conferencing, because really it's the court that's toxic. The other problem is that it's underused by both, I guess. But really the police need to know that they're able to do this and follow up with it. But only 5% of kids end up going through youth justice conferencing. Now, that's pretty low for something that has a pretty high success rate, 15 to 20% decrease in reoffending, according to the Bureau of Crime Statistics. So, really, it's probably something that should be used more, and especially more by the police.